Hi guys, welcome to my channel once again. This is Batok with Ola and my name is Mujala Oluwa. Please don't forget to subscribe to the channel as you enjoy the content on the channel. As you already know, the channel is for laymen, law students and lawyers. So whichever one you are, you will always find something of value each time you come here. Today I want to talk about two often overlooked procedures in court. And that is how to discharge your witness and how to close your case. If you've watched the video on conducting a civil trial or how civil proceedings are conducted in court, you will know that at the end, when your witness has stated what he wants from the court and he's been cross-examined and re-examined, the next thing is for him or her to step out of the witness box so you can call the next witness or so you can proceed in the matter as appropriate. When you're done with a witness, he or she cannot just step out of the witness box except the court discharges them. But that discharge is dependent on you asking the court for it. It's not automatic. So you would often find out that when you're done with a witness, the court would ask you, what should I do with your witness? If you don't know what you should do or what you should ask of the court. The court might ask you, should I send him to prison? Should I send her to the prison? That's because the court cannot just allow the witness to go and the witness cannot just step out of the witness box except you ask for it. So the court will make an order regarding that. So when you're done with a witness, that is when the witness has been examined, cross-examined and re-examined, you tell the court, my lord, may I apply that the witness be discharged? Very important. My lord, may I apply that the witness be discharged? My lord, may I humbly apply that the witness be discharged? So when you've asked that, the court will make an order, witness discharged, and then the registrar will signal to the witness to step out and step down from the witness box. That's the only lawful means by which your witness can leave the box and be free to go home or wherever he wants to go. But aside that, your witness cannot just leave and the court will not ask him to leave or her to leave automatically, and you cannot even signal to them to leave automatically without the leave of court. So you ask the court, my lord, may I humbly apply that she be discharged? And the court will make an order, witness is discharged, you can go. And then the court will signal or the registrar will signal to the witness to step out of the witness box and go back to their seat. So that's how to discharge a witness during trial. It could be civil, it could be criminal. Whichever type of trial it is, you have to apply that the witness be discharged. The second thing I want to talk about today is how to close your case. So you know that you open your case by calling your witness, your first witness, examining them, then giving them up for cross-examination by the other party and then re-examining them if necessary. And then you call the next witness and call the next witness. So when you're done with all the witnesses in your case, the next thing is for you to close the case. And you close your case by one simple sentence. You say to the court, that's the case of the prosecution, my lord. Or that's the case of the defense, my lord. That's the case of the claimant, my lord. It's very simple. If you do not say that, your case is still open and the court will not close it automatically for you. So you need to close your case so that the other party can open their own. And even if you are the next party, the second party in a matter, when you're done as well, you need to close your case and tell the court, my lord, that's the case for the defense. My lord, that's the case for the respondent, depending on whichever type of trial it is. So if, for instance, you have said, my lord, that's the case for the claimant or that's the case for the prosecution, the court will now make an order for the defense to enter their own defense in the matter or to open their own case. But if you are the second person, second party closing your case, the court can now ask both of you when you want to come back to adopt your written address, and then you can pick a date, an adjournment, so that both of you can go and file your written addresses, exchange them, and come back to court to adopt them. But essentially, you have to make that statement, my lord, that's our case before the court. My lord, that's the case of the claimant before the court. My lord, that's the case of the defendant before the court. My lord, that's the case of the prosecution before the court. So in this video, I've talked about two things: how to close your case and how to discharge your witness. Those two are often overlooked, but they are essential as they can be crucial or, very instrumental to the case going on or stalling during proceedings. So that's all I have for you in this video. Don't forget to subscribe. I will always see you in my very next video. Toodles!